UGC, this is
Where is the order still?
and other batch of cases have given the copy. I think alert Mr. case is different.
Issue is identical.
Issues, and I have given that batch of cases. Yesterday I have given that batch of cases. These are also. In fact, dispute matter, two types of judgments are there. In one case, that your lordship has held that since they are transferred earlier, they are appointed against clause 2 post. Subsequently, they are appointed to clause 3 post. That the UGC guideline is not applicable to clause 2 school, clause 2 post. They are not entitled to UGC. In some cases, the lordship has held that since there is no gap in their appointment, so they may be granted UGC. Here, where your lordship has allowed their fair, we have approached the Honorable Supreme Court, in those cases, those are pending. So, I feel this matter will be adjourned for some time, that after disposal of.
But this was filed when? This is of 2020.
I have given that a batch of cases also that are posted to May, that not been 4th of May.
It will come on 4th of May.
May.
Let it come on 4th of May first.
But not date first.
No date first. The order has been started with.
So let's not call this matter after 6th of May. Let's not call this matter after 6th of May. Perhaps it is likely to be listed on 3rd May.
That matter is to be listed on 3rd.
Yes, madam. That UGC matter is to be listed before the Honorable Apex Court on 3rd May.
We will list it after.
Yes, yes, madam.
No, before some of the question.
Before some of it. After last day before like this closer. Last day 17th. It has been pointed out by the AGA that an order passed by this court dated 28/8/2019 in WPC number 16917 of 2017 has been stayed by the Supreme Court by an order dated 19/5/2020 passed in SLP bracketed civil diary number 7967 of 2020. So, copy of the said order has been produced before us, which is taken on record. So, it is not in dispute that the petitioners, that the appellants case in the present appeal depends upon the outcome of the said SLP, outcome of the matter pending before the Supreme Court.
And also batch of cases. I have also given a batch of cases. All are that.
So same day.
Yes, this one same.
All orders are
To 61/4.
My lord, my humble submission, so with due respect, this is different footing. This may be different footing because there are under qualification. I have the deceased employee was qualified having MPhil and PhD degree. This may be different issue.
You were appointed as +2 or
Initially, all the lecturers were appointed against a +2.
Yes.
First post of a +2 got UGC. Third post of a lecturer got UGC. I am holding second post. Denied UGC.
so got UGC by what?
My lord,
By virtue of an order or by
by virtue of an order, they have granted first post, those who appointed +2. So much. And third court by order of this honorable court upheld by the honorable appeals court.
So is there any decision of the state that second post should be granted, UGC scale?
Minor, that is first court and second court, if they are eligible.
See,
Minor, you will also, yeah.
this matter on.
Item number 2.
Item number 2, your lordships, it's a violation of an interim order of this court. Your lordships will find that interim order has been quoted at page 5 of the brief.
And where is that matter pending?
Lordships, that matter actually is of court number 3, but all the contents will be, it will go here. And you know, the writ is there on record today.
It's there along with that what a contempt original writ application is
Also there before your lordships.
it's for final decision.
Yeah, lordships, actually the interim was this, that
This order was passed in WPC number 25805 of 2017. Where is that matter listed?
that matter is pending. The record is there today before your lordships.
No record. The matter,
Matter is still pending.
the matter is to be listed before writ bench.
Yes, but the record is there. Yeah, the record is there.
The record is not important. We want that writ petition and this contempt petition, both of them should be taken up together.
Lordships have, but because of the assignment, this is the
Assignment, we can.
lordships. You know, they should not go forward with the construction. The property was of the education trust. They had a OGB's proceeding and it went to their favor. They had in fact violated the court orders and looted the property and also started the construction.
Yes, why have you done that?
Yes.
Why have you disobeyed?
It's a government property. Like the government took over all the private school institutions inside the state laws. And on that basis, this high school was also taken over by the state government.
There's an order in the lordships.
It's a government school. Now, after thereafter, we applied for the government applied for the correctional record of right in favor of the government instead of the private school. And I will file counterfeit. They stated the original there was
Both the applications shall be taken to.
That's not the merit of the matter. Anyways, we were protected. That's what they should not have violated. We should not have gone for the construction.
In the present contempt application, the petitioner has alleged disobedience of an order dated 20/4/2018, passed in WPC number 25805
Yes, your lordships.
of 2017, interim order. Interim. So the said WPC number 25805 of 2017 is still pending. So list this matter along with WPC number 25805 of 2017 before appropriate.
Yes.
item number 3.
Your lordship, item number 3 can be passed over, your lordship. I'm seeking for a passover by seniors engagement. He'll be after.
As requested on behalf of the, how many adjournments have you taken?
Your lordship,
Many adjournments have been taken.
he's
How
on
many
his
adjournments?
legs. He's apparently in a different court.
All right. As requested on behalf of the appellant, list this matter on 1 week.
Item number 4.
Last order, my lord, for the order dated 2024, order number 6. Ashok Kumar Parija, Advocate General has a public before the court and office order issued today regularizing the service of the petitioner is allowed that the court's order dated 13/7/2022. The said office will be taken on record. If further submitted petition shall be given consequential submission within a period of 5 weeks. He submitted the change in a minor education which are tenders complementary activity for delayed
Yes, whether it has been complied with or not.
So, Manoj, they have filed an affidavit that 1,72,000 and some more.
That was the affidavit earlier.
Yes.
Yes, 1,72,000 and some more amount has not been paid. They have filed a complaint affidavit. And with regard to Manoj, with regard to pension Manoj, they have made it silent. I am filing an today's affidavit Manoj. I have submitted representation on 22nd. That gave me the balance amount for two compliance of the court's order. So,
So let us see the order first.
yes,
Because without any delay, we have complied, we have paid 172,000, provisional pension amounting to rupees 3,124 per month has already been sanctioned. What else my friend wants, I don't know. You will also kindly look at the orders passed on 24th.
on 24th Manoj, that payment was done. Today's petition.
24th it has been done.
Yes, when they are paid, Manoj, I don't.
I can give a copy to my friend. I'm saying that you also look at the pension order.
Yes. Tell us what have you done?
Yes, you can also kindly look at this.
That is a privileged communication, Mr.
Yes, 1,72,900. It's a communication to us, yes,
Yes.
by the chief engineer.
Yes.
Yes, it has been paid on.
So that is a privileged communication between the client, your client and you.
No, I wanted to show you along to show you.
Yes.
So it has been paid on 24th years of this month. 24th, 2024 years.
What have you done?
1,72,937 has been credited to the accounts.
1,72,000
937
against? Against what?
against the area salary loss. Any loss also may say.
Yes.
And provisional pension has already been sanctioned as per the pension rules.
Yes.
By the office order number 1061 dated 24/4/2024.
Yes. These two things have been done.
Yes, those are the so for regular pension, but because regulation is been made very recently, it shall be he has to submit the pension papers, thereafter regular pension also. It will be very score.
Mr. Samantara, additional government advocate representing the contemners has submitted that a sum of rupees 1,72,937 has already been credited in the petitioner's account on 24/4/2024 against areas of salary.
Yes,
Areas of salary. First off, he further submits that provisional pension has also been sanctioned by letter dated 1061, letter number 1061 dated 24/4/2004 24. First off, he submits that a process for sanction of final pension shall be initiated after the petitioner submits his pension papers. First off, he submits that this court's order violation of which has been alleged in the present contempt application has been fully complied with. First off, next in such view of the matter, the present contempt proceeding stands dropped.
That is various salary or differential salary?
and because you are not regular, it's after regulation, you said that you had paid 2 lakh and 1,70,000 was balance out of 4 lakhs.
That is differential.
Differential also.
Balance amount of differential salary.
Differential salary.
Because you are not, you are also differential.
That is what he is claiming. The differential amount of 1,70,000.
What is the differential?
Only the differential amounts. Because
How differential?
Because you are not getting any salary balance, you are getting only.
I was getting the salary balance, that is on a DLR basis. And subsequently regularized balance, that data differential.
Against differentials. Salary. Yes.
That is what you have written in your reply affidavit.
Yes, boss.
Yes.
Item number 5.
Even item number 5 will not say.
Lawsuit said directed me to get that notification where the collector has been authorized by the state government as per section 3 of the OPS Act, and in section rule 4 of the Procedural. I needed each time because the secretary was within that.
No, as requested on behalf of the state, list this matter on 2 weeks. We are granting you 2 weeks, Mr.
Yes. Item number 6.
Another very interim order.
Interim orders shall continue in the meantime.
How do you make a middle?
Yes.
No, please. Well, this is a public interest litigation. The National County Perus, a cement ready mix plant is being installed just adjacent to the village to the locality, and apart from that, one Anganwadi center is functioning within 50 meters of the area, and the daily heavy vehicles are being run within the area. Apart from that, the National County down to Annexure 3 on the basis of the complaint lodged by the villagers. Annexure 3 was issued by the BLC, directing the opposite party number 8 to produce relevant clearance certificates and NOC from the district administration. That was not produced. Annexure 4 number. Another letter was issued by the CMC, directing the pollution control. No pollution clearance is there, no NOC from the district administration. Apart from that, Annexure 5 was issued by the sub-collector, directing the villagers to remain present for hearing of their complaint. Both the villagers remain present, but no hearing was conducted. No clearance is there. Pollution clearance is not there. Local administration, district administration clearance is not there. No NOC, and apart from that, it is being installed just within 50 to 100 meters away from the locality. More than 7,000 villagers are staying there. And very small children are there in the Anganwadi center. The heavy vehicles are being running daily throughout the village road.
So since when this is this mixture plant?
That I have given the ROR, I have given under Annexure 1 and this case map, plot number 770. Page 16 is the map.
You want this concrete mixture plant to be closed?
Not to be closed, it should be installed everywhere else, madam. Not just.
Since when it is there? This is the question.
Just now it is going to start.
It has not started.
No.
So where is the question of closure? All right.
I was questioning that it is ready to start. Without getting any clearance, it is ready to start. And when the vehicles are coming, heavy vehicles with the materials for the village road.
So when the construction work had started?
In November 2023, madam. On 7/12/2023, we lost the complaint. The National County, where is my birth chart? I give him. On 21st December 2023, letter issued by the opposite party number 4, that is the collector district magistrate, to the opposite party number 6, that is the CMC, to take appropriate action on our complaint. Then on 3rd January 2024.
Yes, file your affidavit. Yes. The statutory clearances have not been obtained. This is what he is alleging.
Yes, I will file my affidavit so far as yes, opposite parties. If you also look at the, I can appear for one. Yes, 4, 5, 6, 5 and 7 minutes. Your also only issue notice to minutes state for 2 and 8 minutes. Rest I can minutes 3.
6 also. 6 you cannot appeal.
6 minutes DNC I can appear minutes. District
No, no, 6 is Cuttack Municipal Corporation.
Oh, sorry, no, for municipal corporation I cannot appear. 5 I can appear minutes.
What about 2?
Who is pollution control but they've got their own panel of lawyers.
And 3?
Mostly were pollution control board authority and 8 is the opposite. Both pollution control board you can issue notice 2, 3, 6 and 8 minutes also you can issue notice. Rest I can appear now.
Who is 8?
8 is the party who is installing that mixer center. Their allegation is that private company who is installing that.
We will not issue notice to 8. We will first have the issue notice to respondents number 1 to opposite party number 1 to 7. So when an AGA accepts notice on behalf of opposite parties number 1, 4, 5 and 7.
Yes, yes.
Stop. Let requisites be filed for service of notice upon respondents number 2, 3 and 6
Yes.
to registered post 80, 1 week, 4 weeks. Yes.
Last. Item number 7.
Next is when the expert will also directed the instruction of the government council manager. Now the guidelines of the OCST matter to get scholarship. Yes.
My lord, yesterday directed me to take instruction. My lord, actually these students are eligible to get scholarship. What is happening? An inquiry has happened, has been conducted. Now these institutes are, my lord, misusing this. They are collecting the certificate because 35,000 to get. They are opening the accounts. ATM is in the name of students. ATM is the institution. The students are not being benefited. So we have conducted an inquiry. The report has gone to the SCST department. My lord gives me 2 weeks time. I'll file a detailed affidavit. My lord, if my lord will be satisfied, my lord will protect the interest of the students.
But students are, their studies are to be protected. They cannot.
My lord, the question is here, it's the institute who is playing the mischief, not the students.
This was, of course, this was our observation. But that observation is based on perception that cannot be a basis for decision.
My lord,
All right. But how will you protect their interest in the meanwhile? How shall you ensure? They are studying, there is no doubt. The students are studying in those institutions. There is no doubt.
my lord, that inquiry report has gone. I have just, they're coming because yesterday they have only sent me all this.
How much time will it take for you to file your affidavit?
My lord, within 10 days I can file a complete affidavit.
So let us wait. Yesterday is the last day for filing. Apply for the scholarship. Yesterday was the last date for apply for the scholarship. Date may change.
That will protect, no problem. Once my lord sees that inquiry report, my lord will pass orders and will immediately.
You will see. Students have been admitted by the government. Government so satisfied that the institution is correct and the affiliated to government.
It's fine. We are directing the state to file affidavit. He is making statement that he will protect your interest also. After he appraises us regarding that report and other.
Today is the last date. Yesterday was the last date. Yesterday was, then that is over. They take protection. We will see.
Yes, my lord,
2 weeks time is allowed for the state to file an exhaustive counter affidavit.
Yeah.
But this is PIL. No matter PLL.
No, this is not PR, students have come.
The item is the
We are also interested to see the interest of students to be, but
You want your institution's name should be there in the web portal so that you can apply.
My lord, that is.
it's an institute which is now under scrutiny because of all wrongdoings. That's what we have
But
found.
students should not suffer.
Yes, no, that's exactly. Students should not suffer.
See, if they have participated in a process of selection
My lord.
and they were allocated institutions by you in a process of counseling, they must have been allotted the colleges, no?
My lord, the government have selected throughout the Odisha, government have selected the students, thereafter, according to merit, they have admitted the concerned institution.
I'll see to it.
Allowed for the state to file exhaustive counter affidavit. It is the, have we noted the earlier? There is no order passed. The petitioners claim that they are entitled for scholarship under the scheme of the state government for students pursuing their technical courses,
My taking the ICA, my lord.
ITI course.
University Training Institute,
pursuing ITI
ICA, my lord.
ITI courses belonging to schedule caste,
SC, my lord.
belonging to schedule caste, schedule tribe category. Stop. It is their grievance that the institutions, that technical institutes allotted to one institute,
Number, I give to my lord.
and now we file one writ petition.
My lord, there are different students from different.
I writ petition.
I give to the.
Tell again. Technical institutions which have been allocated to them by the government for pursuing the course have not been notified in the web portal. Have not been notified
The government web portal,
in the
State scholarship portal.
in the
state scholarships portal.
Portal, my lord.
in the government portal for state government's scholarship quota.
No, state scholarship portal, my lord.
State scholarship
Portal,
quota.
my lord.
State scholarship portal.
My
State scholarship portal. Now portal लिखा है ना. So stop. Because of the absence of the names of the institutions in the state scholarship portal, comma, these petitioners have been denied the benefits of the scheme.
my lord.
Stop. The court expects that while filing the counter affidavit, the respondents shall also look into the genuine grievances of the petitioners. All right.
My lord.
This matter on. When we mention that while filing your counter affidavit, you will take into account their genuine grievances, so that is an indication
Yes, no,
that you can extend.
we are looking at that notice, my lord, how
Yes.
to send it directly to students. That we are working on.
There are two problems. If you send it directly to the institutions may avail that differently. If you send them to the students may leave these codes and both situations are possible. But
We are
still,
actively working.
so policy.
No. My lord, give me 10 days time.
2 weeks.
My lord, so blessed.
Item number 8.
May I please, your lordship. Here, this is a PIL by the villagers, my lord. Here, the grievance of the villagers is there is no irrigation facilities to the agricultural lands of the village. And the second one is the railway line, one railway line is crossing in between the agricultural land, and there is no way to cross that railway line. The petitioners represented before the authorities. Thereafter, as per the order of the collector, the concerned tahsildar has conducted an field inquiry. The lordship kindly see annexure 5, page 31.
Yes.
This is a letter to the collector after the field inquiry conducted by the tahsildar. Here, as per your order, I made an inquiry regarding farmer distress due to laying of the railway tracks and non-availability of water in their fields. It is found that there is no facility of irrigation in Mirzapur Mauza because most of the canals, so and so canal, are blocked with sand and mud. A letter regarding the above issue has been written to the irrigation department for early action at their end. Thereafter, the
Yes, file your affidavit. This is important
Yeah, we do that. Yes, ma'am.
matter. How much time? 4 weeks?
4 weeks time.
4 weeks time is allowed for the state to file counter affidavit dealing with the grievances raised by the petitioners in the present writ application. After taking into account the reports of tahsildar,
yes, my lord, tahsildar.
there is only one report. There is only one report.
One report, madam.
Report of
22 months.
tahsildar dated 2/8/2022. Tahsildar TD,
Tahsildar Tihiri,
TD,
TIHIDI.
ED dated 2/8/2022. So, the court expects that the state government, that the state, if satisfied, it is illegal. The court expects that if the authorities, state authorities are of the view that the petitioners have genuine grievance in the light of the genuine grievance, particularly genuine grievance which has been supported in the report dated 2/8/2022 of Tahsildar TD, they shall come out with proposal to resolve the grievances of the petitioners.
Population.
No, railway is not a party. I'll take a notice for accept notice for all other except 9, my lords.
9.
9 is the Chief Executive Officer, Dhamara Port Company.
Who is for railway?
And railway, they have not made railway party.
Here the railway line has been constructed by the Dhamara port.
All right,
Yes, I'll do that.
you have to ensure that their interest is protected.
Yes, replacement.
Population.
Item 9.
May I please, your lordship.
The Ignorance Lordship's order has been complied with. Rupees 32,28,367 has been received by the petitioner on 24/4 by your receiving the check and giving endorsement in the your books of account.
It is stated by learned AGA representing the condemners that this court's order, violation of which has been alleged in the present contempt application, has been fully complied with comma, with the payment of a sum of rupees
32 lakhs, 28,367.
by way of check.
Check number 503 dated 24/4/2024.
503 dated 24/4/2024.
Yes.
So 24 was, it seems, important date for you. All the orders have been applied, all right. Uh, Taking into account this is submission made on behalf of the contemners, the contempt proceeding stands dropped as in the court's opinion, considering the subsequent conduct of the contemners and disobedience as alleged in the contempt application cannot be said to be intentional and willful.
The same department, the lawsuits were pleased to direct the additional chief secretary. She was appearing in the lawsuit through virtual Mohammed.
Yes.
Her department, she has complied all the.
All the orders. So therefore, we are saying that give us the list of such cases
Which have been complied.
in which the orders have been complied with.
Right.
We can get those matters listed and at least get rid of those cases.
I will do that one. Item number 10.
Order dated 3/8/23.
My order has complied by the Commission of Environment, my lord. The preliminary inquiry and the complied order, my lord.
My evidence did not comply, my lord. You are so kind.
Let us see the order first.
Yes, ma'am. Order dated 3/8/23, my lord. Case 13.
Annexure,
Yes. Case annexure 1, my lord. Case 13. One advocate appear on behalf of petitioner and submits each client orders made representation dated 27 May 23 to several authorities, including the Commissioner of Endowments. Events in the representation was irregularities in dealing with the proponents offered to the deity on receipt of the copy of the representation undersecretary to government by letter dated 3rd June 23, enclosed copy of this requesting immediate step to be taken in the matter with the intimation to the department. Nothing has been done, which is why petitioner is referred this court. Director para 4, madam. We think fit to direct the commissioner to act on the representation by making the inquiry as such. Counter is not necessary to be filed because we have not ourselves gone into the allegation. There is no order. And para 5. Petitioner will communicate this order to opposite party number 3. Said opposite party will inform decisions to action taken on the given petition within 4 weeks to the order.
are you communicating?
Now we are communicated, my lord.
It is communicated.
Lawsuit kindly their complaints affidavit, madam. They lawsuit directed the Commissioner of Endowments, Commissioner of Endowments, the inquiry made by the Deputy Commissioner of Endowments, and he said that on perusal of the preliminary inquiry report submitted by Deputy Commissioner, it noticed that the bank account statement has been verified and other documents relied upon by the complainant during course of preliminary inquiry. The present complainant has received the report recently on 19/4/24 and it needs some time to verify, madam. They're not compliant, madam. Still in represent still in not disposed of, madam.
My lord, here is the matter that the deputy case commissioner inquiry, because the commissioner is the punishment authority, so that cannot be inquiry. So the deputy commissioner inquiry, they have the report has been sent to the petitioner, my lord. If you also direction to file a detailed inquiry, we have no option for 2 weeks.
Page 5 of the complex report, paragraph 8 and 9, madam.
It is absolutely no order.
Yes.
Just a paragraph order. Paragraph to made inquiry and dispose of
We think it fit to direct commissioner to act
at on the representation, madam,
on the representation.
by making the inquiry, madam. As such, thereafter next page, madam. Page paragraph 5.
You are seeing that.
Petitioner will communicate this order to appeal party number 3. Said appeal party will inform decision action taken on grievance to petitioner within 4 weeks thereafter.
They have communicated.
The community lordship is to direct to commissioner of international.
No, correct.
Where they say, my lord,
Yes, sir.
inquiry, after getting inquiry report, the commissioner said that he only received 19 and he still needs some time.
See, what is the order? The order is party will inform decision / action.
My lord,
Taken on the grievance.
my lord.
The action has been communicated to you.
But still, my lord, they are not.
There is no such order.
They know, they are not submitted an inquiry. And I think my lord also kindly, Contempt himself stated that he needs some time, my lord.
The petitioner has raised in the present contempt application disobedience of this court's order dated 3/8/2023 passed in WPC number 24072 of 2023. So, operating portion of this said order reads as follows: dash 4 and 5. Stop. A compliance affidavit has been filed in this case stating that an inquiry was conducted and action taken on the petitioner's grievance has been communicated to him through letter dated.
They communicated only, my lord, yesterday, my lord. Only yesterday.
My lord, 18/4/2024, they have confirmed. 18/4/2024, my lord.
18/4/2024.
You must can see the 18 for the letter dated is 22/4, my lord. You must can see their contact.
All right.
This is the letter dated.
Through a letter dated 18/4/2024. Learned counsel for the petitioner states that he has received the said communication on 22.
And this letter, this.
You see, there are two things.
Yesterday.
A letter of 5th can be dispatched on 8th,
Yes,
but the date of the letter shall remain 5th.
my lord. Or in the said letter, they say the report is under consideration of the commission and the citizen.
This is the action taken.
This
Report is undertaken. There is no direction that to take a decision.
the no decision taken, or
No direction to take a decision. There is no direction. The action taken is what
yes. Inform decision, my lord.
when did you receive the communication?
Yesterday, my lord.
On stop. Considering the nature of order passed by this court, violation of which has been alleged in the present contempt application, in our considered opinion, no case of disobedience of this court's order is made out. Stop. The present contempt application stands dropped accordingly. Stop. It goes without saying that the petitioner shall be at liberty to raise his grievance before appropriate authority in accordance with law relating to his grievances.
Item number 11.
Lordship, there is a delay of 15 days.
15 days.
Yes, my lord.
What is your explanation?
Lordship, at the time of filing appeal, the appellant was of 72 years old, and in the meantime, the appellant has been died.
That is not a good explanation. Why should we allow?
Only 15 days, your lordship.
15 days is a big. Who is the other side?
I'm up.
Out. All right. All right, we have allowed.
Oh, bless you.
Mr. Father, in the resolution, appropriate hearing as restoration.
Item 12.
May I please? Lordship, I can well batch of cases. Sorry, man. I have to work as. Sorry. No, so,
Convention of delay.
no, man. But there is no limitation.
There is no delay.
There is no delay.
So why these matters have been listed for orders?
Why it has come on last occasion, the batch of matters were there before my lords. While segregating those matters, I have given a list of 6 categories. Your lordship segregated 1 category. The rest of the matters has come today for orders. May I tell you, it can be out of these, some matters can be segregated. You may give that numbers so that you also can segregate and can dispose of all these matters. Of the lesson is C12. It is up to WA number 825 of 2021. Next page, my lord.
Just a minute. Can you give us list?
8192825. 8192825. First 7 cases. That was a separate category. Well, I am appearing for the respondents. 8192825.
Just a minute. What do you want, Mr.?
If your lordship will take up these matters, can dispose of in course of the day also. So,
Can do that.
if your lordship will fix it for admission any day next, your lordship can 88192 825, my lord.
825.
My lord. All these matters are of same category.
Yes.
Here they have claimed regularization.
Yes.
Then, my lord, 825,
825 we have mentioned, 819 to 825.
my lord. Then 856, my lord.
Yes.
This may be segregated from this category. Why this is not similar? Here, my lord, one that has been disposed of taking into account order passing another case, which is the subject matter of challenge in before the Honorable Apex Court. That is both 856 and 939 of 2022. These 2 matters may be segregated.
So how many cases are listed today?
Around 25-30 cases, my lord.
25. So you have, these are 8 plus 2.
Then I am coming, ma'am. Then my lordship at 901. 901 1303 of 2022, 1308 of 2022,
1308.
8, my lord.
Yes.
These matters can be fixed to Monday along with W number 137 of 2022. And lordship has fixed the matters for disposal on Monday. On Monday. W number 137 of 2022.
Yes.
Then another matter, ever my lord, that is election my 9. Delhi 901. 901. Hello. Delhi पैसे का 1303. टिकी सर मुझे टिकी खाली कही थी आपको मत कंफ्यूज करो. मैं दे यार कंफ्यूज हूँ मैडम. I am
All right. Please don't do it.
because they have some matters.
Let us see.
But then, 925 of 2022, it is a complete different matter. It is to be segregated. Then my lord, what W1 for 5/2 of 2022. This is regarding old pension. This is not regularization, but it can be segregated.
In that case, please let him complete. We'll revert back to you. Yes.
W number 192 of 2023. 192 of 2023. This is regarding work charge employee regulation. It can be segregated. So, if all these matter, if your lordship will take up matter,
No, the 8 to 10, 3, 13 and 3, 16. What about 9 other matters?
sorry, I couldn't.
How 25? Where? 16.
I am not calculated.
There are altogether 16 matters.
16 matters.
Yes. So, who is there in 819 to 825?
I am for the respondent.
You are paid.
Yes. I have also filed the stay petition in 4 cases. Out of 7, my lord, in 4 cases, stay, there is a stay, and I have filed the vacation for stay.
So these matters can be taken up, my lord.
So we have this take up. We can begin from 819.
Other matters can be segregated.
We will first check up 819. Yes. What you had to say, Mr. Tom?
That case, W1452 of 2022, my lord, they identically issued where the last week before the Honorable Apex Court, the same issue.
So we are segregating, we will be segregating this matter.
So I pray, my lord, let it after doing so that I have a certified copy, I will.
2 weeks. In the Supreme Court, the matter has been decided.
My lord, already in the last week it was dismissed, the SLP filed by the state.
You have got the order.
That order was not uploaded, but
Uploaded. Now it has been uploaded.
like today also I verified.
All right, no issue.
But was no issue.
Yes. Anything else? Yes. Did you want to say something? No. Okay. Yes. So what is there in 819?
Yes, may I submit my list? 819 in fact, 819 and 820. Notice has not been issued. I don't have the copy of writ appeal. But 821 to 825, I have received the copies of the writ appeal. So for better manners, your lordship may request that 821 your lordship may take up.
It has come
821.
for condemnation of delay. 819 has come for condemnation of delay.
During Corona, they are filed all these writ appeals and 821 to 825, 821 to 25, delay has been condoned. And 819, 820, no order has been passed, only it has been tagged to these cases. So 821, your lordship may take up time. 821.
So let's say 819 of 2021, there is an IA 1991 of 2021, that is for condemnation of delay. In fact, there is no delay because it has been filed during that COVID period.
The stamp reporter has
Because
shown
at that point of time, when that Supreme Court judgment has not come, so stamp report. You'll also see that order is on 4/8/2021.
4/8/21 the judgment was passed and valid presentation was 27/10/2021. So it's already like it's judgment covers up to February 22. So this can be condoned.
Yes, there is no delay.
No, what
Just say that it is not barred by limitation.
not that limitation in view of Supreme Court so much of.
819 and 800?
30.
820.
820. They are not barred by limitation. And in other cases, limitation has been condoned.
And also, there is no delay because during that COVID period. So that has been dealt with. But these two IAs have not been dealt with in two writ appeals. So you'll also like dispose of those IAs, my lord, by condoning that delay.
Listen, 819 to 825. जितना भी आइए है फॉर कंडोनेशन और डिले। सॉरी उसमें 19 में ये कितना करोगे? What is the number in 819?
1991 of 2021.
1991 of 2021 and 820?
820 मतलब 1994 of 2021.
1994 of 2021 फर्स्ट ऑर्डर जो है वो बात करोगे आइए नंबर 1991 of 2021 लास्ट and 1994 of 2022 ठीक है। पहला है इन 819 and दूसरा है 820 so these applications have been filed for condonation or delay in preferring these appeals. So, however, in the light of Supreme Court's order so and so moto, we are of the view that there is no delay in filing these appeals. IE number so and so, these applications stand disposed of accordingly. Yes, I
May I point out in W825 of 2021, there is also I for condemnation of delay.
which is
825 of 2021,
yes,
there is also I for condemnation of, there is also no delay.
no 825 could be closed. What is the IA number?
That is my I number 2009 of 2021.
2009 of 2021. Okay, yeah, 3 minutes, 3 is this one possible. And other 2 cases delay has been cut off.
Yes,
Other 4 cases.
Other
4 cases. Total 7.
other 4 cases. Yes, right. Delay has been. Yes, so can we take up this matter today? These matters today?
next
Yes,
week, you can fix it. Additional also, you can-
These matters.
You sir, copy of.
I am serving just now. I am serving.
820.
List these matters on 1 week. On Monday, not on Monday, to be Monday as first case for admission. As first cases for admission. Under first. First admission. Under the heading. Huh? Interrogatory applications.
For the results.
Last week calling it on Monday.
Not this Monday,
Next.
next Monday.
Good.
May 22.
819 and 820, copy of the return.
Just now.
First one. Nine, we are delinking these matters. 925, 1452, 192. WPC number 92522, 145222 and 19223. Let these matters be de-linked from the present batch of cases. First off, why this should be listed after 2 weeks, 1452?
Very good. That is the judgment of the Honorable Apex Court is to come, that has not been uploaded, so
All right, dealing list these matters under the same heading, whether they are barred by limitation.
no, madam, that is not. There is an I for condonation of delay.
925 is not to be 925.
Delay of 290 days. Mr. Khuntia, 925 you wanted to be segregated.
925. No, look. Yes, 9/25 it will be submitted.
25.
Yes.
There is a delay up to 90 days. Because Mr. Sanjay is.
That there perhaps that COVID period is there.
No,
Yes, ma'am.
beyond COVID period.
No, ma'am. Because 9/20/2022, I'm looking at that.
You filed, when have you filed?
That has not been,
You have filed on 12th,
12/7/2022. So
appeal was filed. Supreme Court judgment covers up to May.
May 1/6/20, till 1/6/2022.
29 May.
1/6.
29th May.
No, yes, 19, your lordship is correct, because 90 days.
10th January 2022 order says,
Yes, ma'am.
from February 29,
Yes, madam, your lordship is
90 days.
Yes, ma'am, your lordship.
90 days is not 3 months.
No, madam, that I am admitting that 90 days means it is 29th May. So I am wrong by saying that from.
So beyond that, Supreme Court judgment will not cover you.
No, madam, so that from that is the limitation starts. If you lordship
So
that.
further limitation can be considered. That subject to
What is the limitation? Further limitation can be concluded. How much delay after?
after May, it is around 1.5 months or so.
35 or 40 days still.
Have you given your copy?
Yes, I have given. That judgment of honorable apex court.
No.
Yes, I have given.
Do you have any objection?
Well, lordship may condone the delay, subject to payment of nominal cost. I am watching.
You will get.
Substantially included.
Year number 9/25 of 2022. This appeal is barred by limitation. And accordingly, this application has been filed for condonation of delay. Stop. By virtue of the Supreme Court's orders passed in so and so, the appeal would have been filed by May 2022 date.
You can say
That is filed to the
End of May 2022. So stop.
That's it.
Its appeal has however been filed on 12/7/2022. So, learned counsel for the respondent has not effectively opposed the prayer for condonation of delay. So, sir, condonation of delay. This application is without delay in filing of this appeal stands condoned. List this for admission. On when? On same day. Yes. And what about 14452?
Hello?
1452.
145.
No delay.
Delay, madam. There is delay, madam.
In November 2022, they have filed.
But on that is filed on 3/11, there around 100 some days later.
After the COVID, the judgment also 6 months. Thereafter also.
Have you filed any objection?
That I have not filed.
Madam, may I submit one line, madam?
You file it.
if his case will be covered by the.
All right, therefore file your objection.
Yes, my lord. No, what I am saying, my lord, if that Supreme, his cases will be covered by the Supreme Court judgment, my lord, your lordship can dismiss my writ to appeal in accordance with that judgment, so there will be no necessity on it. Your lordship can simply adjourn it.
Leave this matter on 2 weeks under the same heading. Yes, this 192 of 2023 is to be segregated.
Yes, my lord, that is the work that your lordship has, that is similar to W 432 of 2022. It is come for this in the list.
No, but first of all, whether delay has been condoned.
No, my lord, there is no, that delay has not been.
104 days delay.
104 days.
104 days delay.
No.
Oh, should we issue notice?
My notice has been issued.
Notice has been issued.
My lord, on 24 to 2023, my lord, notice has been issued.
So you want this matter to be listed along with what?
Along with W number 432 of 2022.
When is that matter coming?
That matter is coming next week, my lord. What was the agency? Next week, it is coming next week.
List. No, but we'll have to either condone the delay or and this be listed along with those matters.
Yes, I will listen it.
All heard learned counsel for the parties, IA number. What is the IA number?
In that IA number, my lord, 474 of 2023, my lord.
474 of 2023. There is delay of 9 days in filing the present Court appeal. Considering the explanation put forth in this application, we are satisfied that the appellants have been able to
192. 104 days delay.
I need pardon, my learned friend is saying that in that case, notice has not been issued, but my order sheet shows notices.
just
My regulation
190, just
192.
192. Notice issued.
Filing of certified copy was dispensed with. List on 25th April. Thereafter,
No notice.
so that my learned friend has pointed so.
Correctly. Issue notice on the point of limitation. 192. 192. Yes. So all others have been passed?
My sir,
Category letter. This is number 901/2022.
W
901/2022.
901. What is there? 901?
901, 1303 and 1308.
you are appearing for
Yes, my lord, I filed the objection on 24th April, my lords, 1303 and 1308. Your lordship may kindly call along with the objection
1308.
and 1303.
these matters can come on Monday, my lord, along with W number 137 of 2022.
Only along with this objection I have filed, my lords.
WA 901 and
W 901 and 1303 of 2022 and 1308 of 2022. Three matters is to come along with W number 137 of 2022 and also at 50 to 29th of this month.
list these matters on which day?
29th of this month, my lord.
29 for 2024 along with
W number 137 of 2022.
WA number so and so with the consent of the parties.
Because I have also filed an objection that.
All right, we will see.
In two of the cases you are appearing,
Yes, sir.
1303 and 1308. You have filed objection.
Yes, sir. On 24th April, I filed. Grateful.
856 and
My lord, your lordship,
39.
in 856, your lordship, may I point out, my lordship, that order is something different. Your lordship, page 20 of that order. In that case, my lord, this has been disposed of in accordance with the order passed in WPC number 19951 of 2020. So this order was challenging this writ appeal. That writ appeal we have lost here. Again, we have appealed the Honorable Apex Court that is pending before that Honorable. So I pray this matter, these two matters may come after 2 weeks.
Because the matter is pending for Supreme Court.
It's not that I am saying, I cannot
Must be a ground.
what I am submitting, my lord, that your lordship had disposed of the writ petition in terms of the order passed in WPC 1995 of 2021. Since that I am submitting that, since that matter is under sub judice before the Honorable Apex Court.
No, there is the question of, had there been some order, then the matter would have been different.
So my lord, this matter,
Which are the items?
that lordship, that WPC number 8, sorry, W number 8556 of 2022. 856 of 2022.
Unnecessarily, so many matters have been clubbed together.
Yes, my that's why the problem with that, because some matters are different. Those matters are on last occasion we also segregated 99 matters. So those matters will also fit to 29. From this batch, will also segregated already 99 matters.
Yes. Yes, you are referring to which case?
And something value W number 856 and 939 of 2022. So let's not fix any time.
856 and 9?
939 of 2022.
So they are brought by limitation.
No, that is not barber limitation. Sorry, 856. This was filed on 28/6 to 2022. So well, that is 20 days limited.
What is your IN number?
And in 856, IR number is that is no IO is filed for continuation of delay. The SR has not pointed out that for there is no delay matter.
There is no delay.
No, I'm not pointed out, but as it is filed
Which
on
item you are saying?
that 856 matter.
Page number?
Page of the items.
Page of the list.
2144 of 22. IA.
For further orders.
This is 856.
And
856 is at which page?
then next, that one, two, another third page, my lord. Just below 825 of 2021.
No, we are not getting. Which page?
At page 3, third page.
Page 3.
3. Yes. Just below W 825 of 2021.
856.
Well,
So there is no delay.
my lord,
Huh?
my lord, that,
You have filed
but my record, so it is filed on 28/6, so
28/6/22.
2022.
So 90 days delay is shown by the SR.
So no delay.
Yes, madam.
So you have not filed any application, application for conversion.
No, madam.
No, you have filed
No, I have not filed.
856.
856.
There is a delay, sir. You have filed it 28/6/22.
Madam, I have filed, yes, madam. Yeah, 85. Yes, sorry, madam. but the-
Your application for condemnation delay is I number P1/4 of
2022.
22.
I would beg problem forward, please. Confused.
Paragraph 6 is there.
Yes, you are showing 27 days delay.
But sir, I have
Our
not
SR is showing 90 days delay.
90 days.
90 days. Because you have filed
On
in
26.
June, in May.
Yes. So 30 days, maximum 30 days, any matter that 30 days delay, madam, maximum.
30 days.
It is, if it is calculated from 29th May, madam, you filed on 28th, so that is 31 days delay.
But no notice has not been.
Notice has been issued, someone has asked, so. Yes.
The present appeal. This application has been filed for confirmation of delay in filing the present appeal. By virtue of the Supreme Court's orders passed in so and so, the appeal ought to have been filed by
End of May 2022.
end of May 2022. This appeal has, however, been filed on
28/6/2022.
Stop considering appeal filed on behalf of the state of Orissa. Considering the explanation put forth in the application, in this application, delay in filing the appeal stands condoned. Even though when counsel has entered appearance on behalf of the respondents, private respondent, there is no representation on his behalf on call. Stop. Allowed, yes. 939.
939, there is 44 days delay.
In your order, 939. What is the date of filing?
That is the date of filing, 15/7/2022.
15/7/2020. Yes. Yes. Same order. Notices have been received.
Yes.
So what is to be done in these cases? In these two cases?
Some limited condemn, you'll assume condemn that delay.
That we have done.
Yes, my you'll assume fix it to any date after 1 year for admission so that it can be disposed of independently.
These matters for admission. This matter for admission as stress cases.
Order dated 22/9/22. See, this is referred. Notice was served on the respondents through learned counsel appearing for him before the learned single notice, making it returnable before the notice. Mr. Puntia, in WA 939,
Yes, ma'am.
there is an order that notice be served on the respondent through learned counsel appearing for him before the learned single judge, making it returnable before the next date.
Sir,
So you should ensure that. But thereafter, another order was also there. On 3rd November 22, you are directed to file requisites.
Yes, ma'am.
Service of notice.
Hello, that requisition will filed on, requisition filed on 23/11/2022, ma'am.
No, but you have to take first steps.
You have to take fresh steps because
Yes, ma'am.
yes, defects are there, and also notice on admission and stay matter issued to respondent 6 returned undelivered.
I will take,
With report no such person found in the given letter.
39 first steps.
I will take first.
So the orders will not be uploaded unless you go through each and
Yes,
every order.
yes.
Because there are so many matters, we are passing so many orders. There should not be any mistake on the procedural aspect. This is yes. Or
Item 13.
Please. Worship item 13, the notice as shown by the registry is that neither AD nor undelivered notice yet back from respondent 4. I am permitted to take notice on respondent 4. Fresh steps. I will take. There's an IA for delay, 20 days of delay, which is there.
no, who is the other side? You are excellent.
And the appeal.
Who is the other side?
Other side, member board of review, ADM Raigada, sub-collector Raigada, and revenue officer cum Tahsildar Raigada. Notices were sent on point of delay only. On IA,
Except to whom?
to all the respondents, my lords.
You accept notice.
No private. Only respondent 4 is shown,
I think no private respondent.
no private respondent.
How is the delay?
Delay 20 days, my lords.
IA number?
IA number 1223 of
IA
2020.
number 1223 of 2023. Third land counsel for the appellant and the respondents. From considering the averments made in this application, seeking condonation or delay of 24 days,
20 days, my lords.
20 days in referring the present appeal, stands condoned. This application is allowed.
Good.
Yes.
Item 14.
First case.
In item 13, my lord, this is cover my words, order, my lord. So appointment under rehabilitation assistance scheme, my lordship. Yes, yes.
I'm applying for the respondent, madam.
There is also I for condemnation, my lordship.
Yes. Yeah.
Well. Item number 15. Item 15, may I please, the lordship, for this matter, next week or 1 week after. Because some matters that relating to that regularization of laboratory technicians, so that pharmacies. So, your lordship,
But I have these matters come for
limitation on condemnation of delays. See, if all other matters will be decided, matter, it can be covered. Matter. So, if you may call this matter next week or 1 week after.
My lord, I am for the respondent. Identical issue, my lord, on 16/4/2024. Honorable Apex Court, basing on the SLP was dismissed. Order was yet to be uploaded on 16/4. Apart from that, 650 days delay is there in both these.
so we will see. So we will see after that order is uploaded, we will find out all such matters which are pending and all the cases shall be listed and disposed of.
Yes, ma'am, that I am.
That can be done.
Yes, ma'am.
Yes,
It was written for ourselves because your lordship on the last day directed that to segregate those where the stamp reporter delay was not pointed out, there was a two batch of cases. So by segregating only these four cases, your lordship directed those were delayed that may be listed for orders and those were not delayed that may be listed for admission. Which out of 20 cases, which were segregated, and in these cases, more than 600 days delayed. Apart from that, Honorable Apex Court order is.
What we suggest
My lord.
that let these matters come as they are under the heading for orders
My lord.
after 2 weeks.
Yes, my lord.
So in the meanwhile, if that order comes,
My lord.
then all such matters which are covered by this order shall be listed together either for orders or for admission. Yes, but all the matters shall be there together so that all of them are disposed of.
My lord. That is after.
As jointly requested, list this matter on 2 weeks. As jointly requested on behalf of the parties.
Still, my lord, there is a delay of 44 days in filing of the appeal.
16. Yes, who is the other side?
The Orissa Staff Selection Commission.
Staff Selection Commission.
Notice. They have a council, but not really he can appear. I'll inform him.
From him, but why is this system not developing here? That some standing council is there to receive notices.
Here, my lord, those who are standing councils, they are receiving notice. So a panel of councils are there.
No, standing council means those who can at least one lawyer or at least an office.
No,
Whether where the notices can be received.
this system should be there.
Particularly where they have quite number of cases.
No.
So I will serve a copy upon Mr. S.N. Patnaik, who was appearing before the Honorable Single Judge for the Orissa Staff Selection Commission. May I be permitted to serve a copy on him? May I be permitted to serve a copy on him, Mr. S.N. Patnaik, who was appearing before the Honorable Single Judge for Orissa Staff Selection Commission.
But he may say that he does not have the authority to respond.
If not,
All right, let it come tomorrow. Tomorrow we'll see.
you inform if at all he can be present.
Tomorrow we'll take up the matter.
tomorrow.
Monday we will take up the matter. Ask him if he can appear. And in the meanwhile, we will also see what can be done.
My lord. 17.
In 17, two matters are there. May I will also take up 1752 of 2022, the next matter.
Seven.
1752.
Well, the next matter, why I am submitting a first matter was disposed of in terms of the order part in that case.
But this is also marked by limitation.
No, well, in 70, delay is condoned, madam. In 7,
Delay has been condoned.
yes, madam, in 1752 of 2023, delay has been condoned. My long hand is up here.
All right. Let us see what is there.
Madam. And it's sir, one page 22 input order, madam.
There is an order dated 13/3/2024.
Sorry, ma'am.
There
Sorry.
is an order dated 13/3/2024. We have observed, it is manifest from the order under appeal that the writ petition has been disposed of in the light of order dated such and such. An appeal has been preferred against the said order of the landed civilians giving rise to WA number 1752.
Yes, now that is the next matter. I am pressing that 1752. This has come for orders because he has filed an application for vacation of interim order. I am ready, you can hear this matter. It's a very small matter. I finish it within 5 minutes, madam. Can I turn to page 22, annexure 1, madam. I will draw my lord's notice to page 52, paragraph 19, madam. May I read, madam?
Yes.
Taking into consider the factual and legal aspects as delineated above, this court is of the considered view that the opposite parties cannot deny the benefit of regularization of service to the petitioner as level by assistant teacher, and the petitioner has got requisite academic qualification and has also adequate training qualification and otherwise also satisfy the eligibility criteria for regulation. Therefore, non-acquisition of OTT qualification, he cannot be denied the benefit of regulation. If the petitioner has not acquired OTT qualification by 31st March 2019, he may not be entitled to incremental benefits, but that ipso facto cannot deny the benefit of regulation to him. Accordingly, this court directs the opposite party to regularize the service of the petitioner as level 5 assistant teacher on completion of 8 years of Ganashiksha as per the notification dated 22/12/2016. As he has already retired from service, he should be extended such benefit nationally from the date of completion of 8 years as Ganashiksha by regularizing service as level 5 assistant teacher. Since the petitioner has already retired, his pension will be revived and he should be granted pensionary benefits in the revised scale of pay admissible to him by fixing the same nationally as expressly as possible, preferably within a period of 3 months from the date of communication of this order. So far as regularization is concerned, state has no grievance for the time being. And he has been regularized in the meantime as per the orders of the Honorable Apex Court in another case. And by that regulation, he has been granted the benefit of 2 years more. Here, this case, Honorable Single has directed to regularize after completion of 8 years as Ganashiksha. After completion of 8 years as Ganashiksha. Now we have made a policy decision. By virtue of that policy decision, those Ganashiksha who have completed 6 years, they are regularized. There is no dispute that. So far as pension is concerned, the only dispute and this order is contrary to the order passed by the Honorable Division Bench. Initially, he was appointed under a scheme. That scheme is Ganashiksha EGS, Education Guaranteed Scheme. I appointed under a scheme and subsequently regularized, so that if service rendered under scheme cannot be taken into account for the purpose of pension. That is the judgment of this different dates.
What is the date of the division bench decision?
That is 7/4/2022. LRC.
And what is the date of decision of this
A subsequent
order?
11/11/2022. And another judgment also. Another judgment.
We are very cunningly placing the materials. I am using cunningly. So after scheme came to an end, you took a policy decision to not to cease their work, but
No, yes,
to shift them to some other,
to regularize them as assistant teacher.
let them continue in that.
Assistant teacher, so that they can get the benefit from the date of their regularization. Madam, this petitioner was after training in 1997, madam.
No, whether your case is whether the decision of this court in case of Chandrasekhar has any application in your case or not?
And I have not gone through that, but I think that is so difference there because I am serving as teacher in the J scheme since 2001, madam. Thereafter, I am continuing there, though I am getting low salary, but I have acquired proper qualification since 97 as CT qualified.
No, but that period cannot be counted for the purpose of grant of pensionary benefit. That is the only question.
My lord,
Otherwise, everything has been given to you.
my lord, according to Gratuity Act, the person who is working in their post, student calculation is there according to Gratuity Act. So I think, I may humbly submission that period should be considered as pensional benefit. Maybe realize that, but the period who is working there, so in the government, getting no salary.
That is right. See, you get pension because there is a rule, pension rules.
My
You
lord.
get pension under the pension rules.
Madam,
So how can that service qualify for the grant of, for computation of period of pension?
yeah,
There is
that-
no such
that
provision.
is also not clarified. That is also not clarified in this improving judgment manner. You only there seeking benefit, pensional benefit will be allowed.
Then we can clarify that.
That is not that disputed.
All right, let us see the,
So that is not the, that is only pension benefit, nothing else. That is not clarified what they say.
as he has already retired from service, he should be extended
No, no.
such when
Benefit.
notionally
Notional.
from the date of completion of 8 years.
Madam. That is also not clarified. So that is not disputable.
Where is the order in this case, which says that that period shall be
Well,
completed?
I must say that since they are not entitled to pension, my lord, because they are appointed in 2008. they are regularized, if this order is implemented, they have to be regularized in 2016. But as per the condition, we have regularized them in 2014 as per the direction of this Honorable Supreme Court also.
No, they were appointed in 2008,
My lord.
8
As Gana Shikshaka.
EGS scheme,
My lord.
EGS,
My lord. EGS scheme as Gana Shikshak,
and it came to be regularized since.
2014, my,
How can you get pension?
yes, that I am saying, my lord. And he retired in 2020.
How can you get pension?
That I am submitting that Dr. Cassidy is very clarified because yes, Dr. Cassidy is very clarified that as I am that pension will be conducted. Maybe under the new pension scheme or old pension.
Straight then so will be getting.
Because now they have also allowed my cover on the new pension scheme. In their order, they have also covered me in the new pension scheme.
Now, we will also make clarify, we are one
Subject to qualifying survey.
if he said it to be covered under new pensions, that will also say that he is covered. I am submitting it to be covered under new pension scheme.
The state of Orissa has referred the present intra-court appeal questioning the correctness of an order dated 11/11/2022 passed in WPC number 15345 of 2022. The operative portion of the said order reads thus. First off, it is not in dispute that the respondent was engaged as as engaged as Gana Shikshak in 2008.
Date may be specific, 5/7/2008.
5/7/2008. 5/7/2008.
And he joined on 11/7/2008.
Whereupon, you're looking?
He did not change his page. That the respondent was engaged as Guna Shikshak on 5/7/2008.
With effect, was appointed as on 5/7/2008, subsequent to which, pursuant to which he had joined on
11/7/2008, my lord.
11/7/2008 under EGS scheme.
EGS scheme, employee
Guaranteed scheme.
Education guarantee.
The education guaranteed scheme, my lord. EGS.
Education guaranteed scheme. To stop. Next. Learn AGA representing the state of Bihar, the state of Odisha has submitted that there is that the services of the respondent have already been regularized and the state does not dispute the direction issued by the learned single judge in the impugned judgment to the extent it relates to regularization of the service of the respondent. Stop. He has, however, submitted that the respondent is not entitled to any pension as
Now, we will actually clarify pension under old pension, Odisha Civil Service Pension Rules 1992.
pension under the Odisha pension rules.
There is a civil service pension rules
Odisha
1990.
service,
Civil service, my lord.
civil service pension rules
1992, my lord.
1992.
My lord.
Full stop. He has submitted that if the order passed by the learned single judge is clarified to this said extent, comma, the purpose of the present appeal shall be served.
Yes,
So he has submitted that in any case, the respondent cannot claim pension under the said pension rules.
well,
Stop. Next. Then counsel, the respondent does not dispute the submission that the respondent is not entitled to pension in accordance with Odisha Civil Service Pension Rules.
yes,
Odisha Civil Service Pension Rules 1992. Stop. However, he is entitled to get pensionary benefits, retirement benefits under new pension scheme. Stop. Considering the submissions advanced on behalf of the parties as noted above, this appeal stands disposed of with an observation that the order passed by the learned single judge dated 11/11/2022 shall not be read as conferring any right upon the petitioner to get pension in accordance with Odisha Civil Service Pension Rules 1992. Stop. This appeal stands disposed of accordingly.
But I have been already covered in the new pension scheme. They have
Mentioned. The only clarification which is there in our order is that you will not be entitled to pension under the pension rules. That's all. Everything you will get.
No. My lord, the first matter is for regularization, my lord.
first matter is covered in that. The we will also see the order that has been disposed of in terms of this order.
So first matter is for regularization. I have not been regularized till yet. With the pendency of the writ and subsequently regarding the qualification of OTT,
I have not been regularized. You can file a contempt application.
I have already filed, that is pending, my lord.
So therefore, now your case will become stronger.
You will also refer my submission will be regularized. You will also refer my submission to that extent.
See.
Your order has same. When was the date of his appointment?
31/5/2008.
Huh?
31/5/2008.
31/5/2008. Joined on
2/6/2008.
2/6/2008. आपकी वजह है ठीक है next learned counsel appearing on behalf of the respondent has however submitted that despite the order issued by despite the order which is under challenge in the present writ appeal passed by the learned single judge, the respondent has not been service of the respondent has not been regularized. So, learned counsel, learned AGA appearing on behalf of the appellant has submitted that the respondent's services shall be regularized in terms of the direction issued by the learned single judge.
Then he will be loser, my lord. You will also say that
In accordance with in accordance with the
say that in accordance with the
in accordance with the government policy, which is more beneficial to
yes, I
him
have before that
than what has been held in by the learned single judge.
2 years benefit.
Right?
Yes. Public. Item number 18.
There are two defects. But one is the impugned order 5, where if it is the impugned order has not been annexed, not been given. But if that can be, this is the order. Impugned order is this. This is the dismissal of the non-prosecution. And 5B, the second defect may be ignored because this state copy. And
No, whether your application has been, this appeal has been restored.
no, not has been restored.
It is
It was a restoration today. Restoration, there is a initiating is that I have not filed the IU for condonation of delay. The 10 days delay has been pointed out by the stamp reporter.
10 days.
10 days.
Someone is appealing for the other side.
State commercial tax.
Yes, should we restore?
Maybe this 10 days.
Commercial taxes, nobody is appearing.
I think commercial tax department is opposite party. Mr. Misra is to appear.
Commercial tax.
Commercial.
Have you served copy in?
Copy is served. Otherwise, I will call him. I will just now call him if you are not.
It's a copy of the present restoration application. Be served on London Council who represents the.
No, Mr. Sunil Misra, London Council.
Yes, Mr.
Beg your pardon.
Do you oppose?
Delay condemnation.
You don't have a copy.
No,
Give him a copy.
I'll give you a copy.
This matter on Monday. Let's do
Notice.
Monday.
Let's see, please call.
In course of the day, if I serve him, your lordship can take it up. 10 days delay if it can.
Let him have a vote.
I don't have to.
There are two applications, Mr. Council, one for restoration, the other for delay.
So delay application has not been filed. That is the defect which has come.
Fine.
So 10 days delay.
10 days delay, what?
I will formal I is to be filed.
You find it.
Defect number 5A and B may be ignored.
What is that?
The defect which has been pointed out, one is the impugned order, but I have given the.
All right, we ignore that. Then
And second is copy. The copy of the state council, I will give a copy.
this matter on Monday. No, 1 week. So as to enable London Council representing the petitioner to file an application for condonation of delay. Post office. That copy of the present restoration application and condonation of delay application be served upon Mr. Sunil Misra,
Standing Council of
Standing Council, Commercial Taxes. Yes. Other
Defects you ignore.
defects as pointed out by the stamp reporter stand ignored.
Item 19.
My lord. Item 19. This is a private dispute. Your lordship may kindly see order dated 19th April 2024. Your lordship has already admitted the writ petition,
by a recent order dated 19/4 that there is a prima facie case and the notice has been issued. But there was a IA filed for interim order, interim stay that was not taken up and no order has been passed. That is why another IA was filed and it is now listed for orders. What has happened, my lords? There is an hour passed by
So
the
you are for?
petitioner. The other side is also the private opposite party who has lodged the complaint before the tribunal, and that complaint was allowed by an hour, which is available at page 26, 27. Lordship may see. Writ petition has already been admitted by your lordship and notice has been issued. Now only this page 27 may kindly be seen. This is complaint case number 3 of 2018. Sudarshan Panigrahi is the complainant, who is the opposite partner 1, and Satyavata is the respondent, who is the petitioner.
Please come to order dated 19/4/2024.
Yes, my lord. Yes, my lord. Issue notice to the opposite parties by restorer returned within 4 days, request for which must be filed within 1 week. That has already been complied. Only thing is that I
No, 19/4/2000, yes.
24.
So the issue which is involved, that has been noted in,
Yes, my lord. So I am not pressing that. That your lordship has already taken into cognizance and order has been passed, notice has been issued. Only thing is that along with the writ petition, one IA was filed for an interim order, which was not taken up, no order was passed in the IA. So again, I have filed in IA that since the matter is pending, no coercive action may be taken at the instance of the opposite partner 1, because he is now pressing. Your lordship may kindly imagine only one sentence I will say. The award was 1 lakh rupees with interest.
no, whatever, see, whatever relief you are seeking, you can seek before the,
No, appeal is not admitted because your lordship may see appeal has not been admitted because that the impugned order was passed rejecting my application for exemption of this stamp. That pre-deposit. That is challenged before the honorable. So you say that you have already deposited some 10 lakhs rupees. My lord, against 1 lakh rupees hour, I have deposited 10 lakhs with interest.
You have said 5
5 lakhs, earlier 4 lakhs and around 9 lakhs, para 6 of the reputation.
5 lakhs you have deposited
Yes, ma'am.
in the course of execution.
Execution. That is why. In the execution procedure. Para 6 of the writ petition.
who is appealing?
No, notice has been recently, your lordship, we have filed the requisites. I pray that
19/4.
otherwise, the
IA number 5667 of 2024. This application has been filed.
on that day, the IA could not be praised. That is why no order was passed.
Application has been filed. Asking the file seeking a direction to the special certificate officer Bhubaneswar not to take any coercive step against the petitioner in connection with OPDR case number 113 of 2019. So in this case, notices have been issued in the main matter to one person.
Only one person. Since the tribunal has also been added as a
To the opposite party number 1. To the opposite party number 1. First off, while issuing notice, the court had issued the order. The court this court had noted as thus paragraph 4. First off, taking into account what has been observed in the aforesaid order of this court, which is dated. What is the date of that order?
19/4.
19th April.
19/4/2024. We direct that
My lord, annexure 5 may kindly receive. Page 32, direction be issued to the certificate officer who is now executing
we direct that
the special certificate officer Bhubaneswar.
that the special certificate officer Bhubaneswar shall not take any coercive step against the petitioner
Pursuant to the order in execution case number 6 of 19.
pursuant to the order
Of order in execution case number 6 of 19 of Odisha Real Estate Regulatory
page
Authority.
number. Where is that number?
But this number is 113, sir. This number is 113.
Please.
Answer 5. Answer 5.
No, that was pending, that is pending. No, I'm not pursuant. For the next, this, the page 31 may kindly send. That is the execution case. Page 31. Pursuant to the order of the regulatory authority, that your lordship can, that will solve the purpose.
Then what is that 113?
113 is the, in that case,
That is
OPD.
OPDR.
OPD.
OPDR Act.
But this is execution.
Execution.
This is the execution is by RERA.
Execution case. Execution case number
6 of 19, page 31 of the deputation. 6 of 2019, passed by Sudarshan Panigrahi, opposite Patna 1.
That is Annexure 4.
Annexure 4. 6 of 19 of ORERA, Orissa Real Estate Regulatory Authority.
this order has been passed by ORERA,
Yes, my lord, this is
not by a person.
No. ORERA was the tribunal. Yes.
Yes, ORERA is the
The
tribunal.
opposite Patna 1 was the complainant, my client was the respondent before the order.
But direction cannot be issued to special certificate officer. If special certificate officer, he is proceeding in OPD on the basis number 113 of 2019.
On the basis of this order,
So
execution case order. That your lordship is also hearing in another matter, your lordship must be remembering.
Pursuant to the order dated 13/3/2019, passed in execution case number 6 of 19.
Yes, that is the original case. That is the obliged.
Yes.
This much information about the earlier date.
Just this matter of. So this the date fix here. That. Yes.
Item 20.
I plead the lordship. And the appellant in the case not before this intra-court appeal, but there is 2 days delay that is in order. It's in kind.
Condone.
It's in kindly call it on any day next week. Yes, I'm
2 days delay control. This appeal for fresh admission.
Item 21.
This appeal has.
Under the heading of proceedings.
Under the heading press admission.
I'm sorry, Lord, Lordship has fixed it. Lordship has fixed any date. Lordship has fixed any date, not in the case.
It will be listed. Press admission, it will be listed automatically.
Item 21.
Item 21, my lord, this is that workshop regularization. Most of the criminals have kept that matter to 29th, Monday, for hearing. But this is, that batch is without limitation. This is each limitation. So this, for this batch, no date has been fixed. My lord, may kindly adjourn it to 2 weeks after, then I will disposal of that.
Item 22.
There is private parties. I have kindly, I didn't know. And that's
Let me condone in case of state of delay. Such delay can be condoned when the appeals are filed by the estate.
I'm 22 million item. Not this one. And I have explained the delay within
Which item? Yes.
in paragraph 3, and it's the medical certificates.
Yes, who is for the other side?
The private party notice has to go on.
Issue notice. What is this about?
My lord,
What is this case about?
during the challenge, the civil judge ordered to challenge that when the execution is filed, in execution case, the appellant has no notice and later we came to know that, and thereafter we challenge the,
How to maintain this appeal? Why should we entertain it?
my lord, I have taken that ground.
Mister, your application before the single judge was filed under Article 227 of the Constitution.
My lord,
So no writ appeal will lie against such order. So why should you unnecessarily issue notice?
there is order 226.
We are dismissing your.
Let it come Monday, I will explain the order of this. It is filed, Mr. Pati, well, this case is emanating from civil court's order, my lord, judicial order, my lord, execution case, my lord. So this, leave aside everything, full court decision affirmed by Supreme Court, my lord. This, full bench decision of this court has been upheld by Supreme Court.
Item number 23.
You let it come on Monday, I will verify, my lord.
No,
I will. Kindly move on Monday, my lord, I will verify that. Only Monday, my lord.
Yes. So, let's this matter on as requested on behalf of the appellant to satisfy this court on the point of maintainability of this appeal. List this matter on Monday as the first case.
Yes, Monday, my lord, it first case.
Monday is the first case.
Yes, yes, Monday.
Item 20.
10 days delay there. I submitted the medical certificate.
10 days.
10 days delay.
What is this order about? The order?
Notice about the announcement of the
Data.
cases.
What is needed?
And if I go into, if your lordship is satisfied, then I will be going into it.
Yes. 20 days delay. Well, control.
10 days delay.
10 days.
10 days.
Press admission.
For admission item 24.
Usual, Mike, usual.
Item 24, my lords, is a jail reforms PIM. My lords, yesterday, my lords have directed me to take instructions on whether the wards which have been completed, my lords, at the Bhadrak jail, whether they can be shifted or not. That's my instructions are that this Bhadrak jail, a new complex which is being constructed. So only the wards are completed. Apart from the wards, unless the kitchen and other administrative buildings and all are completed, there cannot be any shifting.
No, but yesterday you gave us an impression that wards have been constructed within the premises of the jail.
Please note, that is what was, in fact, previously, that is the misconception that I probably had. So they said that this is a new jail which is being constructed, and the current jail that will be abandoned after this new jail is constructed. So this new jail has 500 capacity. So out of which 180 capacity wards are only completed. Apart from that, the entire complex needs to have other buildings, which are essential for shifting off. Only after that it can be shifted. Now, in our previous affidavit on 17th of January, we had given a timeline because the executing agency is Odisha Police Housing Welfare Corporation. So they have given a timeline as Odisha Police Housing Welfare Corporation.
So whose welfare?
This is prisons minutes.
No, this Odisha Police Welfare, we can understand Odisha Police Building Construction.
Please minutes. But
What is Odisha
housing, police housing.
Buildings are also.
They may be undertaking, but for welfare. Why this welfare is there in the corporation, this thing? The welfare of the employees or police employees?
No.
Personnel?
No. This is for the inmates and
We have bad experience with them.
What is we must understand. We can understand you have Odisha Police Building Construction Corporation.
Please minutes.
But how do you have Odisha Police Welfare? Whose welfare?
No, this is Odisha State Police Housing and Welfare Corporation.
Housing and welfare.
Housing and Welfare.
Whose welfare? Housing welfare. All right.
So they have given a timeline which my lords will find at our affidavit dated 17th of January. As per that timeline, my lords, the entire complex will be completed by end of June 2027. That is the timeline that has been given by them.
2027.
2027. So 3 years from now, my lords.
Can you imagine? Can you conceive of?
And when had the work started?
Whereas this is the second phase. So as per the timeline, the commencement of the work will be from 1st of November 2024. Because
The work has not started.
the work with regard to the other buildings which have to.
When this project was undertaken, are you constructing Taj Mahal?
No.
So when had this project started?
The first phase, was the construction.
Mr. Please, let us understand. When was the foundation laid for construction of jail?
There was the foundation for this, if I may, the construction of this new jail is being done in 2 phases. The first phase was only for construction of 180 wards. That is, completed. As with regards to the construction of the residential buildings like the administrative building, hospital building, kitchen block, residential building, for those constructions.
Please let us understand when was the work for construction of those wards?
That has not started, till date.
Wards you say that you have been constructed. When had that construction begun?
That construction of the first phase, I do not have exact dates, but today that is completed.
Now, what is the use?
It is only.
Is it habitable and
No,
usable?
it is.
If not, then how can you say that it is completed?
A jail, the new jail complex cannot be used.
What is the use of having 7 wards when you don't have the complex complete? So why are you saying that we have done this, we have done that? You have done nothing.
The timeline given is 2027. By then, what would happen to this words? What would be its condition?
Yes.
And what is the condition of Bhadrak?
Because
How
this
many
is Bhadrak, my lord. This is Bhadrak, my lord.
Other one is Jajpur.
Other
Yeah,
than
Bharat, we are trying to understand what is the,
What my learning friend was saying was
what is
about
the occupancy.
occupancy as on March 2024. It's excess by 60%. So in all, about 81 units are in excess. I'm so sorry, Manoj.
no, my lord.
It is 31% excess. So 63 are in excess.
63?
63 excess, the capacity is 201 and the present population is 260.
Well, if I may touch, as I have got the latest figures with regard to overcrowding. In fact, at Bhadrak, my lords, now the overcrowding is 51% because the capacity is 201 and currently, my lords, as on as of today, my lords, there are 303 inmates in the Bhadrak jail. So that has increased.
And if my lord would allow that table which I had given, across since COVID, from 2020 onwards, Bhadrak and Jajpur, there is no other way except adding capacity. Now, if they are saying that till 2027 we will increase capacity, then they must have a concrete plan for this because for 3 years you can't expect these people to remain in this overcrowded state. And this is something which I have been telling this court since the last 3-4 years. The orders are all there before this court. My Lord Justice Raman would have seen those orders earlier also had shown. These two jails are beyond that committee which has been formed. We cannot do anything. We have to come up with something or think out of the box so far as these two jails are concerned.
How many convicts are there?
As on date, as he says, it's around 300 convicts. Convicts, the breakup, I think he will be good.
I think all inmates.
At jail,
As of today, my lords, there are 46 convicts.
46 convicts, you can shift them to some other jail.
Please, my lords. Because there is a sub-jail, there is a sub-jail at Soro where, my lords, the excess inmates in this jail are transferred, my lords. From time to time, that is the arrangement that is being taken up at Bhadrak. And at that sub-jail Soro, my lords, it has a capacity of 206. And as on today, there are 100 inmates there.
Mr. Counsel, if you want this court to record
Yes, my lords.
that there is failure of state machinery, we can do that. Otherwise, you must come with concrete solution within a week.
Please, my lords.
Otherwise, we will record a finding. We cannot tolerate this.
No, I will find.
They are. Do you know why are they in jail custody? Do you know?
Well, because
They are because of the orders passed by us, the judicial officers, the judiciary.
Yes, my lords.
So we have to ensure that their rights are protected.
Yes.
We cannot leave these issues like that. Come up with some solution within a week. Otherwise, we will hold this.
Please, my lords. I just wanted to bring one other.
And just submit one thing, with your lordship's leave. There is this issue, there are two orders of the Honorable Supreme Court which I have given, where this issue is being taken up now. Those recent orders, my lord, may kindly. Paragraph 6 of that order. So this is something which the state, they are also answerable to the Supreme Court here. Para 6. But I must bring this to your lordship notice because this anyway was going on during COVID also when this PI was being taken. Para 6 is something which they may also, they have to answer the Supreme Court. This is being taken up pan India across all states. Orissa's matter is not yet come up before the Supreme.
Next state.
When was this order passed?
This is 30th of January 2024.
So have you constituted the commission?
That committee has been constituted. In fact, the state has also filed its affidavit before the Honorable Supreme Court. And the matter, because the Supreme Court is taking it phase wise. So on the last date of hearing, 4-5 states they had considered. The next date of hearing, which is slated on 14th of May, Odisha's case will be taken up, where the Supreme Court will deal with these, because there have been meetings convened by this committee in various districts. So those meetings are, the minutes of those meetings are before the Supreme Court. So Supreme Court is also monitoring this this particular issue of overcrowding in jails.
And what about Jajpur?
As with regard to Jajpur, my lords, currently, my lords, the occupancy is 230 and the capacity is 133. And my lords, with regard to Jajpur, my lords, we have already obtained orders from the trial courts by which 26 number of under trial prisoners are going to be shifted from the district jail Jajpur to sub jail Jajpur Road tomorrow, my lords, 27 of April 2024. And similar permission is also being sought for 15 under trial prisoners in Bhadra.
The subsequent order of the Supreme Court also we have got regarding expanding the scope to women.
This is the order.
Subsequent to this.
There's another.
Subsequent order thereafter, just for the court's knowledge. So that 16 to 2024.
24.
16 to 2024.
24. Yes.
On 9th April,
9th April, it was adjourned, and then 23rd order is not yet uploaded, but Orissa, I'm sure that has not yet been taken.
No. Last date.
Even during COVID, these matters were going on in tandem, but there was never any overlap. Like I was bringing these orders to the notice of the court from time to time. So far as that UTPs who have been granted bail and not released on bail, that is something which also in this PI earlier it was taken up. And that is something which your lordships, that the Supreme Court is not looking into that. That now.
in jails also, medical officers are
Medical officers.
they are attending on calls.
Please.
So permanently, they are not doing the duty. Only pharmacist is available.
Please.
That is another grave concern for us.
In fact, the moment they go into slightly better things like how to teach them life skills or how they are able to come out, then this issue of overcrowding again comes to the forefront, and then all those issues go to the backbone. Like at one point, when Mr. Chabra was there, he had been instrumental in bringing in mental health issues.
Mental health issues.
Those.
One or two other
Now this overcrowding infrastructure, now that this PIL is there, it is on the Supreme Court. It should be there.
He is satisfied with the timeline given by
Parents.
And what was this PIL was for what?
The present one.
Yes, this PIL.
The present one was actually on the basis of a letter of a prisoner. And in 2014, I was appointed as an amicus to have the model prison manual in place. So the court wanted an amicus, and that's how I came into the picture. And then the model prison manual was subsequently brought about in this state. And thereafter, this was taken up sometime in 2020. And then from during that period, it was taken up from time to time, and all these orders have been passed. My lord, I see the note which is given for April 2024.
No, this matter was registered in 2006. It refers to Krishna,
For creation of infrastructure, then this VC facilities.
where is it?
So there's no concrete prayer initially in the original PI. 2006.
This public interest litigation was filed in 2006 by a public related person seeking direction from this court to the authorities for enforcement of the fundamental rights of the convicts lodged in jail, in various jails in the state under Article 21 of the Constitution of India. First of the petitioner had alleged that the convicts lodged in different jails are subjected to non-stop infringement of human rights. Stop. The issues relating to the right of speedy trial, right to aid, right against custodial torture, etc., were also raised in the present writ application. Full stop. Various orders were passed in this case. Full stop. Full stop. Which is that 2014 order?
2014.
Detailed order passed by
Order number 33 dated 23rd.
no 50. The matter
Number 30.
on 14/12/2014, following order was passed by a division bench of this court. Court kar do. Since then, this matter has been taken up regularly by this court to ensure that the prisoners, under trial and convicts incarcerating in various jails are given due treatment to, and their fundamental rights are protected. Stop. Next, in the present proceeding, we have considered the cases of such under trial prisoners who, despite having been directed to be released on bail, were not being released because of their incapacity to furnish bail bonds. So we have noticed substantial progress in that direction. Stop. A disturbing trend has come to our notice based on the materials available on record, particularly with reference to two jails, namely divisional jail. What is that?
District Jail Bhadrak and District Jail
Bhadrak and District Jail Jajpur. Stop. The District Jail Bhadrak has the capacity to accommodate 201 prisoners.
201.
As against which there are 303 prisoners, 303 prisoners in custody. Stop. Similarly, in District Jail Jajpur, as against the capacity of 133 13 prisoners.
133 minutes.
Yes, 113 prisoners, there are 230 prisoners in custody. That is the double of its capacity. Stop. Then counsel representing the prisons department, prisons has informed this court that as regards Bhadrak, the state has Bhadrak, new district jail is under construction. Stop. The wards, 7 wards have already been constructed.
My lords, 180, a ward of 180 capacity has been constructed.
Wards to, are you constructing such jails? In this jail in the, how can you shift?
Whereas the bigger capacity, it is actually 500 capacity, out of which 180 has been constructed.
New district jail is under construction, and the And as per the instructions, the jail shall be constructed by November 2027,
June 2027.
June 2027. Stop. What about Jajpur?
Well, with regard to Jajpur, the Jajpur also there's a new jail which is being constructed, and as per the timeline given by the agency, it will be completed by 30th of June 2026.
As regards Jajpur, Jajpur Land Council has informed that a new district jail shall be constructed by
30th of June 2026.
30th of June 2026. So, the state has no proposal as on date as to how the they are going to tackle with overcrowding in these two jails till new jails are constructed. So stop. List this matter on 1 week when the state shall be required to inform this court as to what step does it intend to take to tackle the situation of overcrowding in these two jails till the new jails proposed to be constructed, new jails under construction are completed. Anything? We will see on that day. Yes, Mr. You are waiting for some case, Mr. Yes, Mr. You will some time. It will take some time.
It will take some time. Darcy may fix it next week any day. Not 30th, first, second and third. Any date your Darcy may fix. Because 30th I will be absent with my family. So I require some
want to mention item number 32. Yesterday I mentioned before your lordship said that the other side counsel is not there. Now he is there. It may be listed to Monday because the stay order is operating. Your lordship has already had it. Only an instruction was sought for. I have obtained. At 2 p.m. it can be taken up because for last 2 weeks this is.
No, it will come on Monday.
Monday at 2 p.m.
Also, my case may be taken up on Monday.
Item 32.
Monday.
All the cases will
I'm sorry,
come on Monday.
Monday.
And item 33. There are two cases. Mr. Jena is there. He is there.
On 33 item, I need to file a certain documents on Monday.
No, it is there in the list for 2-3 weeks. And he is not filing it now. When I mentioned, he is saying that again.
Only 2 days before he has sought me a copy.
No, 2 days. Last
All right, wait, can you wait,
My lord, by stay order, this.
what you are doing here in the courtroom, you can do that outside once and just wait till Monday.
It may be taken up on Tuesday then.
All right,
Tuesday at 2 p.m.
2 p.m. we can't guarantee.
It will take only 15 minutes.
Then within first 5 cases.
Yes, madam. Obliged.
He appears to be correct.
Your Lordship, so far as this order is concerned, he is correct.
To that extent only. To that extent only.
And so far as the merit of the case.
Merit will come later.
Yes, sir.
So,
Your file application.
My lords, that is I
23 to 2024, which has disposed of the writ petition on the ground of non-availability of what is that tribunal?
GST tribunal.
GST tribunal. So, when counsel for the petitioner appears to be right in his submission that the said order has been passed under an incorrect premise that the writ petition was filed against an appellate order. Huh?
Assessment order.
No.
Appellate.
Against an order passed by the appellate authority. Batch of a separate order passed by the district. The writ petition was disposed of while deciding batch of writ applications, wherein the question of the consequence of non-constitution of the GST tribunal was an issue. So, accordingly, the order dated 23 to 2024 is recalled. Let WPC number 42716 of 2023 be placed for admission.
It was already admitted, you just restored.
Admitted. Your case is admitted.
There was order to take instruction.
Admission, admitted, there is no difference for admission. Yes.
I am for the OPU in this case.
I'm for opposition, no one.
And counsel for the opposite parties have no objection to the prayer made on behalf of the petitioner for recall of this. Cause.
Here is the case, my lord, where my lord, a vehicle was seized loaded with my lord laterite stone. Subsequently, that was seized by police. And it was informed that the quarry was operated by some persons, my lord. And present petition is one of them, my lord. And meantime, one of the quirky, my lord, some of the quirky has been granted there. They are also not present at the spot. They are not present at the spot. It was informed that the quarry was operated by this person.
My lord, there are three anticipatory bail applications before this honorable court, 1, 2, and 3. Arises out of a same PS case. And the first one of the co-accused person has already been released on bail by this honorable court. This is similar. Second one, item number 2, my lord. So far as the item number 2 is concerned, there is no name of the present petitioner in the FIR. My lord, go one by one. So far as the one is concerned, his name is there and he is similar to co-accused. Was granted bail.
There are three applications.
Three applications arise out of the same PS case.
So in first case, bail has been granted.
No, another person has been granted who is similar to this person, the present petitioner.
And second one is not named.
Second one having known.
Second one is my application. It has been named, that is serial number 4.
Where? Serial number 4 is Sanjit Samant Singhar.
It's okay.
You are Supriya.
My name is your lordship, that is
That is Supriya Bahu, that is Kabu Bahu Bolandra, that is Supriya Bahu Bolandra, alias Kabu.
Kabu, you have not mentioned that.
Supriya Bahu Bolandra is his name.
And who was arrested on the spot?
That nobody was arrested, but driver was present at the spot, he fled.
All applications are for anticipatory.
And nobody, and the present person was not present at the spot, my lord. So that's why you also granted bail.
All right, so if you appear before the court below whenever required.
Yes, fine. Yes, fine.
But so far as the item number 2, his name is not in the
That is
FIR.
that is body column, my lord.
Body column is I have gone through.
That is serial number 6, my lord. Kabu Bahu Balendra. That name is
No, Kabu Bahu, you are Supriya Bahu.
that alias Kabu, my lord.
Where is alias?
I am not alias, but my name is same person, Supriya Bahu Balendra. That
You should have mentioned in your petition.
that is mentioned its full name, my lord, that is nickname has been Kabu. But the name is
Have you stated in your application that is the alias name?
people was mentioned.
What can be?
Same person.
He has mentioned in the paragraph, my lord, that he has been accused on the basis of a statement of a co-accused statement.
All
He
right.
has stated. And the last one having 3 similar antecedents.
That is here not present at the spot, man. Only basis of my lord, only that is on inquiry, they found that has been managed by the petitioner. He has not present at the spot.
But he has
Similar-
similar offences.
He has not only police has my lord, mentioned that my name, but only on that managed that year. But I was not present at the spot. So other I am similar to other, those are also not present at the spot.
Only difference anticipating that. So far as I will read the
Some gas security or gas.
It is the prosecution's case that who is Jayant Kumar Bhatta? Who is he, Jayant Kumar Bhatta?
My lord, he is the informant.
So he is only informant. That is.
Is he a police officer?
Yes, my lord. Yes. Yes, sir. Yes, sir.
That-
Police.
Yes, sir, Sadar of Khurda Police
It is
Station.
the prosecution's case that during the course of patrolling duty, the informant, comma, police officer, comma, based on a secret information, had detained one tipper. What is tipper?
People that is
Vehicle, my lord.
vehicle carrying for my lord, transportation of stores and
Like prop, my lord.
Tipper bracketed a vehicle used for carrying, transporting stones, etc. Comma, bearing registration number OR 16C 6376, loaded with laterite stones. Stop. It is the allegation that the informant learned upon inquiry that the petitioner, along with others, were operating in illegal stone quarry in the area. Stop. Learned counsel for the petitioner has argued that similarly circumstanced co-accused, what is his name?
my lord, Sanjita Samanta Singh.
Sananta
Sanjit Samant Singh and another.
In the column accused number 4, man.
Number
In the accused column, in affair, that is accused.
Samanta जो भी है has been
Page
granted
9, man.
privilege of anticipatory bail by an order dated
order dated by that 19/4/2022.
19/4/2024 passed in
Last in ADL appeal number 3369 of 2020.
Is it correct? Stop considering the he has further submitted that the petitioner was not present at the place of occurrence as is evident from the first information report, and there is no tangible basis to demonstrate the petitioner's involvement in commission of any offence. Stop next. Learned counsel appearing on behalf of the state as state opposing the prayer for anticipatory bail has submitted that the petitioner has criminal antecedent of his involvement in other similar cases.
My lord, so far as the item number 3 is concerned,
Item number, I am dictating in item number 1 only.
my lord, so far 1 is concerned, I have no instruction regarding the criminal acts. Madam, may say subject to verification of criminal acts.
Considering the circumstance that the other co-accused in similar situation has been allowed privilege of anticipatory bail, this application is allowed to
Item 2.
Item 2, his name is not there. My lord, friend is saying, Kapu is there. Kapu alias Bhava. He has
petitioner's name, just a minute. Prosecution's same हो जाएगी. Petitioner's name is not reflected in the FIR. Stop. Learned counsel for the petitioner, however, has submitted that. Who is that person?
That is Supriya Bahubalendra.
Huh?
Kabu Bahubalendra is same person as
Babu Bahendra
is same as Supriya Bahubalendra.
is the alias name of this petitioner. And this petitioner, and therefore he has preferred the present anticipatory bail application. Stop. He has submitted that there is no clear basis for the petitioner's implication, and only on the basis of some vague inquiry, the petitioner has been implicated. Stop. Next. He has further submitted that if granted privilege of anticipatory bail, the petitioner shall present himself before the police for the purpose of investigation, inquiry or investigation, and before the court as and when required. Stop. Considering the aforesaid submission and the facts and circumstances, this application is allowed. Item number 3. What is about 3?
And item number 3, my lord, is also similarly to situated to all the persons. But so my humble submission is really said to and it's of gas.
My lord, can you give a glance to paragraph 5?
That is around.
Yes, you have submitted, not. My lord, can you give a glance to paragraph 5?
That is wrong.
That it is humble submitted the petitioner has no knowledge about the transparent so and so. Implication petitioner is the only member so and so. And because the petitioner has been falsely implicated in 3 similar cases. He has mentioned. I have not mentioned.
Fairly submitting, my lord.
You have it.
Submissions of the father. Similarly, circumstance to accused have been granted bail. जो पहले में लिखवाए थे was not present. पहले का submissions of the father. Learned counsel representing the estate has opposed the prayer for anticipatory bail and has submitted, with reference to the statement made in paragraph 5 of the present application, that petitioner is involved in 3 other criminal cases of same nature, and therefore he should not be granted privilege of anticipatory bail. I'll stop next. Be that as it may, considering the submission, considering the nature of the allegation and the basis of registration of FIR and submission advanced on behalf of the petitioner that he shall present himself before the police and the court below as and when required, this application is allowed. Yes.
Item number 4.
Alice, offense, sir, your lordship, 57, 395 of IPC and 1,027 of Arms Act, your lordship. And so far as the present petitioner is concerned, he is the receiver as per allegation of prosecution's report. He is the receiver of the stolen property, your lordship, 50 kg of copper. And the CJ list says that nothing has been seized here. The copper was not seized from the petitioner, your lordship. In the meanwhile, and another receiver of the stolen property, that is one Bimal Mahali, he has been released on bail by a DJ Special Judge Bhanka Lordship by order dated 20th February 2024. The another co-accused, Gurgovind Pradhan, he has also been released on bail by this honorable court by bail application number 1962 of 2024, by order dated 19th April 2024. And almost all, except one Biswajit, almost all co-accused persons have been released on bail, your lordship.
No, but your application was rejected.
Yes, yes, your lordship. In that case, in last order, your lordship, it is reflected in that order in para 4 that raid was conducted leading to recovery of the stolen copper materials from the petitioner's scrap shop. And the season list shows that nothing has been seized.
No, but your bail application was rejected. Jayaprakash Gupta.
Yes, your lordship.
Your application was rejected on 20.
Then counsel was not aware of the antecedent also that in 3 cases in para 6, your lordship kindly perused para 6 of that order.
Very difficult. You can challenge this order, but not you can not renew the prayer. We cannot review the order which was passed.
Modification of it.
No, nothing. You cannot do anything.
In the bill,
You are sorry.
no, order number in para 6 of that order, your lordship, that is reflected as in as much as he has an accused in 3 cases other than the present one.
Yes.
That is also not true. I have certified copy of forwarding report, your lordship. But in that report, it is clearly mentioned that he has only 2 cases apart from this case, your lordship. That is one from in the year of 2005 and another one in the year of 2019, your lordship.
Therefore, you are doing this from 2009. And you have continued it. 19.
2019.
So,
Receiver of
therefore, section 413 has of
but the other court persons have been.
sorry. The petitioner's prayer for anticipatory bail, for regular bail, was rejected recently on 20 by an order dated 28/2/2024, passed in BL APL number 1089 of 2024. Stop. The petitioner has renewed his prayer for bail by filing the present application. Next, when counsel appearing on behalf of the petitioner has attempted to convince this court that similarly circumstanced co-accused persons have been allowed regular bail. He has also submitted that An incorrect submission was made by on behalf of the estate that the petitioner is an accused in 3 cases other than the present one. Rather, the fact is that he is an accused only in 2 cases other than the present case. So stop. Be that as it may, comma, considering the fact that the petitioner's application for regular bail was recently rejected, comma, I am not inclined to reconsider such prayer. This application is accordingly dismissed. Item number 5.
Modification or less?
No, madam. Item 5.
Item 5, under section 20 B of Omnibus Act. So as per the, time is page 99, my lord.
Page?
Page 9.
Page 9.
Page 9, the Gonzalez is for one research, who disclosed that I have collected the Gonzalez from this petitioner. And page 15 of the schedule list clearly shows at this spot, we have to put Judicial consideration of justice system, and he is not involved in occurrence. Only a statement of the justice system, the police is searching for. Only a statement of justice system. So what do you want? We surrender and we surrender and individual.
On counsel for the petitioner, after some argument, seeks permission to withdraw this petition, this application, with a liberty to surrender before the court below and seek a regular bail. Stop. This application is accordingly dismissed as withdrawn with the liberty as sought.
The principal is already visible. The principal is already visible.
The court will consider. It is made clear that if the petitioner surrenders before the court below within 4 weeks from today, and 6 weeks from today, and seeks regular bail, his case shall be considered on its own merits without being, case for grant of bail shall be considered on its own merits without being prejudiced by dismissal of the present application upon withdrawal.
Item number 6.
Lordship, in this case, on 8th of this month, I have filed an interim application where the main petition is pending with that. On the ground that the mother-in-law and the sister of the petitioner, both they have expired. So to attend the funeral ceremony of the sister and mother-in-law, filed anticipatory interim application to release the petitioner for a period of 2 months, your lordship.
2 months.
Lordship, as desired, my prayer is that there, my lord. So far as my instruction is concerned, the elder sister of the present petition died on High 4/2024. In the meantime, 22 days have already elapsed. Within 11 days, the funeral ceremony, etc. was observed.
And what about mother?
Not mother, mother-in-law, but mother-in-law of applicant died on 2/4/2024. In the meantime, 24 days have already been passed.
What can be done now?
My lord. My lord, I have mentioned twice in that respect, but my lord, the matter has not been listed, my lord. Matter has not been listed, my lord. And this person in the due course of time, my lord. So he is in custody, not attended the funeral ceremony. That is already over. Over just
So your prayer was earlier rejected.
my lord.
Whether your prayer for
But not,
so you are in custody since when? Since when you are in custody?
my lord, I am in custody since 9/10/2023, my lord. In the meantime, my lord, charge sheet has been submitted and all other persons, since all other persons were granted bail. And your lordship also granted one of the accused, those who assaulted the injured. Yes, my lord. Who assaulted the injured, said, who fired towards the injured, and also another person assaulted the injured, that Babu Pradhan, my lord. Your lordship granted bail in bail application number 1050 of 2024, my lord. Which petitioner, my lord, has limited role in this case, my lord. The petitioner never attributed any, never assaulted the injured at any point of time, my lord. As so far as allegation, my lord, against the petitioner, your lordship will find the code below, as mentioned in the rejection order, my lord, the page 9, my lord, paragraph 2, that when Babu Pradhan fired at him, but fortunately the pistol malfunctioned. Then Babu Pradhan assaulted on the head of the injured by the butt of the gun, causing serious bodily injury on his head, whereas Sunil Pradhan assaulted the injured by a Bhujali.
Who are you?
My lord, I myself, Padhu alias Padmacharan Pradhan, my lord. I am not the assailant to the injured, my lord.
What is your name?
My lord, Padmacharan Pradhan, my lord. Padhu alias Padmacharan Pradhan.
What is there against him?
My lord, against him, he head to the assailant.
And he is, since when he is in custody?
He is custody in 3/10/2023 and having 13 antecedents. So far as the other petitioners, other accused person who have already granted bail, they have one person having 3 antecedents and another having 2 antecedents. My lord have considered, and this person is having 13 antecedents. And since 2018, I don't have any antecedents, my lord. 18, prior to 2018, all these antecedents are pure antecedents are there, my lord. In all those cases, my lord, the petitioner has been released on bail and never like the liberty granted to him, attended the court regularly, my lord. And those cases, some of the cases has already also, my lord, come to an
The petitioner is in custody since 3/10/2023. It is the prosecution's case that on 27/6/2023, two co-accused persons, namely Babu Pradhan, accused Babu Pradhan and this petitioner entered into the informant's godown with an intention to kill him. Stop. Accused Babu Pradhan is said to have fired at him, but the attempted to shot fire at him, but the pistol malfunctioned. Stop. Why you have you had not entered?
No, I have not.
You was outside with a motorcycle, again.
नहीं उसके पहले का समझा बाबू प्रधान and this accused Babu Pradhan, Somnath Sahu and Babu Pradhan. Accused, sorry, Babu Pradhan and Sidhu Pradhan.
Yes, Manoj.
Put into.
Sidhu alias Sunil Kumar.
Also, it is alleged that they assaulted the informant with Bhujali asap cutting, a heavy sharp cutting weapon, and wooden planks. Stop. Learned counsel appearing on behalf of the petitioner has submitted that there is no allegation of any assault against the petitioner. There is no allegation.
No.
Stop. Learned counsel appearing on behalf of the state has, however, submitted that petitioner has criminal antecedent since he is involved in at least 12 criminal cases.
13 numbers.
Present case
1, 3.
12 criminal cases other than the present one. Stop. He has submitted that on this said ground alone, the petitioner's prayer for regular bail deserves to be rejected. In response to the aforesaid submission made on behalf of the estate, learned counsel appearing on behalf of the petitioner has submitted that all the 12 cases are of 2018 and beyond. First of he further submits that in all the said cases, the petitioner is on bail and has never misused the privilege of bail. Stop. Next, considering the circumstance, considering the nature of allegation against the petitioner emerging from the FIR, in my opinion, a case is mirrored for grant of regular bail. The application is accordingly allowed.
Item number 7.
Offense is under section 20B to save the ambiguous act, my lord. The allegation against the present petition is that while the petitioner eliminated 4 levies where standing rest said, my lord, the police arrived there and ganja was seized from them. The present petitioner 20 kg of ganja was seized, my lord. And he is custodian 9/3/24.
Not now.
9/3/24.
Not now.
No. And other co-accused also granted bail, my lord.
Not now, Mr. Where is that order? Where is that order granting bail?
My lord's order. 27/3/24, my lord.
So, but from your possession, 22 was recovered.
My lord.
So this will not apply 27/3/2024.
Last occasion, my lord directed to obtain the CBN.
I have already received case type. That is that. 22 kg has been recovered from this petition. And
Antecedent. Antecedent.
antecedent has not.
But still, how 37, you are covered by 37, your case is covered by 37. Huh? Not now. She was granted bail because of her, the amount recovered from her possession.
Any stringent condition, my lord?
Any?
Any stringent condition? He will.
Senior's condition.
Any strict condition, my lord?
Any?
Any hardened condition, my lord?
No, no. Because of the bar, we cannot, that embargo. 27/3/2024. The order है इसमें 3 kg यहाँ पर है ना 22 kg का considering the circumstance that from the petitioner's possession, allegedly, more than commercial quantity of ganja was recovered. I am not inclined to grant the petitioner privilege of regular bail for the present. This application is accordingly rejected.
Item 8.
My lord, last occasion, my lord had directed to take instruction about the well-being of the petitioner. I have taken, he has expired since long. I have received instruction from Contempt police station, and also death certificate is also there. So it will be competent.
There is no representation on behalf of the petitioner. Also, on the previous day, when this matter was taken up, the court had required that counsel for the estate to get a report as to whether the petitioner is alive or not. First of all, he has produced before the court a report of
IIC, Contempt police station. Petition was present.
officer in charge. What is IIC?
IIC Contempt, my lord. Inspector in charge. Inspector in charge of Contempt police station.
Inspector in charge, Khandapara police station, to the effect that the petitioner died on 19/4/2021 in Hyderabad due to COVID. Stop this application. Thus abates. And stands dismissed. I'll have to raise. Yes.